form of relief that we commonly see, and actually we're seeing it more and more with the young people we see, is something that's called asylum. So asylum you might be familiar with, you might have heard the word, and I'm just going to give you a little bit of clarification. So under U.S. law, a person who has a well-founded fear of persecution on account of race, political opinion, religion, nationality, or membership in a particular social group may seek protection under our asylum laws. Okay, children's cases are a bit different in terms of jurisdiction. So under the TVPRA, that fancy thing that we talked about, Congress gave USCIS, the benefit side of immigration, what's called initial jurisdiction over any asylum application filed on a UAC, an unaccompanied alien child. So that's the definition that Lenny talked about in one of the first couple slides. So what that means is that children who are filing for asylum, who are in removal proceedings, who under normal circumstances, if they were adults, would have had to file an asylum case in front of an immigration judge, now are able to receive the benefit and of affirmative interview with an asylum officer. So this means that they're going to the asylum office, which in New York depends on where you live, but it's either in Rosedale, Queens, or if you live in the Bronx or Manhattan, you're going to be out in Lyndhurst, New Jersey. That there is a non-adversarial interview with an asylum officer as opposed to a trial in immigration court. That's huge. That's a big deal. And the asylum officers, this core of individuals, are supposed to be trained specifically in child-sensitive interviewing techniques and are supposed to be a more appropriate setting to conduct an interview with a child, as opposed to immigration court where that child is defending him or herself in front of a trained prosecutor and a judge is making that decision. Okay. Also a person who is a support person for the child, so that could be a big brother or sister, it could be mom or dad or the guardian or someone else in the child's life, is able to come with the child to that interview at the asylum office, literally to be someone sitting next to the child, to hold the child's hand during the interview and to be there as a source of support. And the asylum office, the experience that we've had with the asylum office in Rosedale, Queens, has that they've been very welcoming to have that person come in and be right there for the child as well. Okay. So in terms of the actual definitions and the law involved with children applying for asylum, there's no different definition of refugee for children. Really all of that stays the same. We have UNHCR, which is from the United Nations, and they have guidelines for children's asylum claims. We have those as well, and we encourage you to look at it. But this is just a slide that explains more about the definition of a refugee, which is what someone is considered when they've applied, when they've been granted asylum in the United States. So the only difference between a refugee, I imagine most of you have heard that term, or asylum, is where that person is applying for and granted that status. So when someone is here in the United States and is applying to be a refugee, they are granted asylum in the United States. When someone is actually, that happens in a different country and they are resettled to the United States, they are considered a refugee. So the legal process happens outside of the borders of the United States. They already effectively receive their legal status and come over, are brought over to the United States as a refugee. Okay, this is more specifics, just a more in-depth look about the definition we're talking about. And then this is important. This is talking about the on account of prong of protected ground. So we have the 5 protected grounds that you can see: race, religion, nationality, membership in a particular social group, or political opinion, and then the on account of ground. None of these protected grounds say children are a protected ground, right? That's not clearly listed here as what the law says. So it's your job as the advocate to figure out how you're going to make this case work in terms of how this child was persecuted or why this child has a well-founded fear of persecution. 2 of the common areas we're seeing are children who have been victims or who fear, again, being victimized by gang activity in their home country. We're talking major organized crime. So this is to both boys and girls who experienced such horrors as to literally not being able to go to school because the gangs had infiltrated the school and they didn't have enough money to pay the daily ransom or the daily extortion money to those gangs. So they were beat up on a daily basis until they reached adolescence, at which time the gangs tried to actively recruit the boys to become members and tried to rape and make the girls become sex slaves for the gangs. It's horrifying, and this is something that we're hearing more and more from the kids we see, is that this has happened to them, and that's why they're coming to the United States. We also see children who have been victims of child abuse. and in their abusive situations, both physical, sexual abuse, in many of the countries, there is no child welfare organization, ACS or DIFAS in New Jersey. That doesn't exist to take care of the child in many countries. So the children, if they're not living with their parents, there are no shelters for children. There's literally nowhere for them to go. They're forced to live on the streets, and eventually, through whatever reason, they make their way here to the United States. And we have seen child abuse and able to be a membership in a particular social group and have children's asylum claims granted successfully. So back up to when I was talking about the gang claims. Unfortunately, there's been a lot of bad case law through the Board of Immigration Appeals, which is our highest immigration authority before things go to the federal courts, about dealing with gangs and dealing with organized crime, predominantly in Central America. So saying that the child was targeted by a gang, that's really oftentimes not enough for the child to be granted asylum. So we push further into why that specific child was targeted. Oftentimes that child is targeted because he or she was a member of a family, right? And perhaps a family member had been into the United States, and so the child was targeted because the gangs and everyone thought that that child's family was wealthier because they had been in the United States and they were living in the United States, so they were specifically targeted. Or for another reason, maybe perhaps the parents' political opinions or even the child's own political opinion. Children can have political opinions. You know, we think of sometimes as children being too young to have things like that, but that's not true. You get children who are actively opposed to being part of the gangs or are in some other way doing activities and being advocates in a way that actually is what is a political opinion, and children can have political opinions. We do also have cases of children who were persecuted on the basis of their religion, and that's also, of course, a valid ground for asylum. But in general, just something to be aware of when we're talking about the gang-based cases, and our asylum training isn't going to talk a lot more about this, is that you need to push a little further and you need to do more research and explore this with your client further. Saying that they were targeted by a gang is really not enough here. We need to push further into that. Okay. Important to remember that asylum is discretionary. So even if your client establishes eligibility for asylum, he or she may still be denied asylum. We have other forms of relief, including withholding of removal and protection under the Convention Against Torture, which is called CAT sometimes, that are able to be accessed that are not discretionary. CAT in particular is not a discretionary form of relief. Asylum is. So that means you need to present evidence of positive discretionary factors that may mitigate any negative discretionary factors. So we're talking about children if there's any criminal issues involved or things like that. Putting more positive factors to outweigh the negative is definitely something that would be helpful. Okay. Okay, so we have discussing this claim with your child. And this is basically breaking it down so that we hope that the child will able to be understand why it is that you're asking him or her all these probing questions in terms of establishing an asylum case for the child. Okay, talking to the child about fear. We have asylum office guidelines, so from our asylum office, that children may be unable to express subjective fear and allow that the objective evidence alone can establish fear. So talking to the child in terms of evidence, in an asylum case, the evidence is most often that person, the applicant's own testimony, and sometimes it's the person's own testimony alone. I've won asylum cases where I have had no other evidence other than that person testifying, and that's been fine. Again, it's case specific and it's discretionary, but just something to keep in mind. So we're talking about a child's affidavit, so helping the child to write an affidavit and to be able to present testimony, meaning to be able to respond to the asylum officer's questions about fear, about what has happened in the past, and or what the child fears happening should he or she return to the country of origin. Also affidavits from friends or family members who perhaps have witnessed what the child has witnessed, and that's something that we encourage only if it's safe for those people to be writing and to be speaking out. Again, if we're talking about horrible conditions in the home country, if the child has been subjected to, well, either past persecution or has this well-founded fear of future persecution, it might not be safe for mom or for grandma or for whoever's in that home country to be writing an affidavit that's going to be sent to the United States, because the immigration encourages those affidavits to be notarized, to be certified by an authority, and so presenting that piece of paper to essentially the government with language that might not necessarily be favorable to the country might be something that would be problematic or dangerous for mom or for grandma. So things to be aware of is affidavits from outside the country, if it's safe for those people to do so. And then lastly, we have country condition information. So this is the objective information. So this is looking at the U.S. Department of State human rights reports, which for the countries of the children we're talking about, those reports are very clear that these countries are dangerous for children. So you don't have that against you, but I encourage you to supplement that with your own additional research, looking at reports by UNICEF, UNHCR. There's tons of materials out there, especially now, especially with all that's going on, about issues in terms of child abuse, in terms of gang-based violence, in terms of gender-based violence, whatever applies to your child here. And then there's the idea of including experts, either for country conditions or experts in terms of doctors, in terms of psychologists also, even social workers, people who have a relationship with the child. For doctors and psychiatrists and psychologists as well, we've been reaching out to the organization Physicians for Human Rights, which is basically a pro bono network of medical professionals who agree to do assessments of anyone, including children, for the purposes of applying for asylum. So that means that the child can talk with that doctor, and that doctor can also write a statement on the child's behalf explaining that this child is suffering from symptoms of PTSD, of post-traumatic stress disorder, or that this child is suffering from anxiety, and that it makes sense from that physician's conversation with the child that the child would be experiencing those things given what the child has gone through and given what the child fears returning to. So things to keep in mind. We're happy to help you reach out to Physicians for Human Rights. It takes a little bit of time. They're a pro bono network just as we are, so it takes a little bit of time for them to be able to place cases. So it's not appropriate for you to call the day before your asylum case and explain that you need an assessment from a free medical professional and please can we help. They need a little bit more time to help you as well. So something to keep in mind, and we encourage you to start thinking about this right from the beginning when you've taken an asylum case from us. Even though you may not be trained in psychological issues, from speaking with your client, even those first couple of times, it might be clear from that child's demeanor that something is going on here. Maybe he or she can't look at you. The child's signals, and we can talk more about that. I didn't really get into to symptoms of trauma here, but that child may be experiencing symptoms of trauma that are best interpreted by a medical professional and not you as the attorney or the advocate. Okay, brief slide of documents to file. There is the I-589 application for asylum, plus the affidavit from the child. We have that, and you want to also always be aware of the idea of inconsistencies. So that means in the I-589, it asks for brief statements about what the child fears or what has happened to the child. You want to make sure that the same information is in that form as is in the child's declaration, that everything you're submitting on behalf of the child is consistent, that dates are consistent, so on and so forth. Identity documents, case-specific supporting documentation, country conditions, affidavits. We don't need really a witness list for the asylum office, that's more for immigration court, but in any case, just a list of the evidence. And also a memorandum of law, which for the asylum office can be a very simple letter brief. This doesn't have to be a memorandum of law if you have represented people in removal proceedings. This doesn't have to be that 30-page brief. This can be a letter brief just laying out the facts of the case and why this child is eligible for asylum. And we have samples of those as well.